state.
I would appear for accused number 7, 8, 9, 23, 25, 26, 27, and 28. I'm also standing in for Mr. Samherji, who's being placed before your sister Shuudifonya in a matter that commences at 10 o'clock. And that would be on behalf of accused number 5, 10, 12, 13, and 14. As the court.
Mr. Gustavo. Mr. Gustavo, you're here?
I am.
Yes. Mr. James Hatuikulipi? Yes. And Mr. Shanghala? Mr. Esau? Thanks. Mr. Who is accused 6?
Mr. Mwatelulo.
Yes, you are there in person. You are here in person, isn't it?
That is correct.
Right, I remember last week I asked you to consult and agree on a program for moving this matter forward. Yes, Mr. Marondezi.
We would like to extend apologies to court that the document was not filed as per the directives of the court. This is solely because the communication between the parties is mainly through emails. And initially the parties had thought that the initiative which had been taken by the registrar to consult the parties about their diaries would suffice, but we realized that we still needed to file the document. So in earnest, we started working on the document yesterday, and it was a back and forth of emails. So by the time the emails were concluded, there was no time to file the document. And the other parties, you've just signed the document now, that is Mr. Siomundje and Mr. Engelbrecht. My Lord, attentive to tender this document signed by all the parties.
Yes.
My Lord, as it appears from the document, the parties simply put on the document what was applicable to them. So this was not necessarily the way of the agreement for the way forward, but each party put what is applicable to them. For particular, the state is only standing by paragraph 3, which refers to the position of the state. That the state is available to continue with this matter.
When?
At any given date, my lord. However, we are amenable to the dates which may be given by the court or convenient to the court and the defense, which includes the unrepresentative accused persons. The state has taken note of the other provisions which apply to the other parties, but it's up to the parties to convince the court on what to accept their positions, my lord.
What's the state position? The other parties have said what?
My lord, the position of the other parties are outlined from paragraph 4. That one is for Mr. Siomunji. He indicated that he's not available on the 2nd of December. However, he could be available on Tuesday at 9 o'clock. He was indeed available today, but unfortunately, the accused persons were brought late. And he indicated in paragraph 5 that he is not available for the remainder of this calendar year to continue with the trial, and is only available as from 19 May 2025. Mr. Engelbrecht is present here. His sentiments his position is reflected in paragraph 6. And he also provided a diary to the registrar. He indicated that he is not available for the rest of this year, and he is only available as from 19 May 2025, as per his diary presented to the registrar. Mr. Shanghala, who is a spokesperson of accused 2 and accused number 6 and accused number 1, indicated that he has filed a review application and that the application will be managed on the 19th of March 2025 by the allocated judge. He separately, which has nothing to do with these proceedings, with this plea, that he requested a particular statement from the state, which the state has undertaken to provide him with a statement. He indicated that, and I think by extension to the other accused persons, his spokesperson, that he also is available to continue as of 19 May 2024, 2025.
Who is that?
Shanghala and company.
That's paragraph 9.
As per paragraph 9.
That's in company refers to
Accused number 1, number 2, and number 6. Accused number 4 indicated that you indicate to this court the status of his legal presentation due to the appeal which has been noted by the state under section 26 of the Prevention of Organized Crime Act. And indeed, he signed in person this document as an unrepresented accused person.
Now, what's the state's attitude to that?
The state,
It's no use saying to me, we want to start now. What is your attitude
the state,
to the proposal that the trial proceeds in May, 19 May 2025?
my lord, the state's position is that it wants to see the back of this case. The state as witnesses, we've been waiting to testify in this matter. Since the matter was transferred to the High Court in April 2021. 2021, yes. My lord,
You said April 2021.
yes. My lord, life belongs to God. Anything can happen to the state witnesses or even to the prosecutors. But if anything happens to the prosecutors, at least some people will be able to take over. But we can't take over when something happens to the witnesses. We've been waiting to testify in this matter. So it's an inconvenience to the state and the witnesses and the nation at large who are eager to see this matter finalized. Not an inconvenience, a prejudice to the state.
So what's the attitude of the state?
The state, my lord, the state wishes this matter to proceed.
When?
Since there's no consensus
All I'm saying
between the
is,
parties.
let it be very easy for you, Mr. Marondezi. You are the state. There is a proposal from parties to say we can't start until May, isn't it?
Yes.
The state should be upfront or clear that no, our position would be, it must start at this time, taking into account your own situation, about your witnesses, everything that you must be able to say, as far as we are concerned, the case must start on this day.
My lord, my submissions are based on in the context that the court directed that if the parties could not reach a consensus on the dates on which this plea recording should continue, the court will come and give its ruling on
And
the dates.
that is why I'm asking you the question, so that I consider your standpoint and I balance it against the standpoint of others.
My lord, the state is ready to proceed as of today, and we request the court to come up to give directives as when we should proceed, given the deadlock between the parties, my lord.
Now, I also want to understand, going by the rules of court, what should happen if a lawyer says I'm not available until May?
My lord, this honorable court has already made a ruling on that to that effect. In the previous judgment, I just don't know which one was that. When the state referred this honorable court to a particular matter with regard to this issue, and this court made a ruling already to that effect that the court is not there for the convenience of defense counsel.
All right, let me narrow down the issue to this. Assuming I say, because you see, you have to respond to the reasonableness or otherwise of what the other parties are saying, so that your position is very clear to me. You see what I'm saying? The other parties have said this. What is the position of the state? Is it practical for you to just say, no, let's proceed now? Does that show practicality having regard to all the factors.
That submission, my lord, was made to emphasize the position that the state is ready to proceed.
But realistically, what is the position of the state? That's what I want to know. Realistically, what does the state propose? If it cannot start now, as you say, let's start now. If it cannot start now, because the court has to take into account what the other parties have said, when does the state say it really must start?
The starting point, my lord, will be that the court, the state will apply to this honorable court to give the parties reasonable time to prepare for the presumption of the plea taking. My lord, reasonable time would mean that we take into account that given these happenings which have been happening in this, the applications which have been before this honorable court, it's understandable that the lawyers made other commitments because it was not certain as to when we are supposed to resume the trial.
Yes, carry on.
And therefore, a reasonable time would be up to the close of business this year, my lord. 15, up to 15 December. They should be able to prepare to put their houses in order, my lord, because, and given the...
what do you mean close of business, 15 December?
Generally, the High Court closes on the 15th.
So what are you saying? We give them time up to 15 December?
Up to 15 January, my lord.
You said December.
December is when we close, the High Court closes business and resumes on the 15th of January.
So we are talking of January?
Yes, my lord, when we start. Because it's understandable that their diaries were committed up to the end of December because it was not certain. The applications had not been resolved. Having said that, my lord, ultimately, we're in the hands of the court.
So all you need to do is to tell me your position.
Yes,
because ultimately it is me who is going to give directions, isn't it?
Yes,
so no need to remind me that it's in my hands. It's in my hands all the time. But I take into account what you guys have submitted, right? Now, and the ability of the court to dictate a date, where does it derive?
My lord, the detector of this court to arrive with the date, ultimately, the first thing is that the court is in charge of the proceedings. And there's a discretion which should be exercised, taking into consideration the submissions which have been made by the parties, whether they are reasonable or not reasonable, or whether they have merit or no merit.
So you're saying it's in the power of the court by virtue of?
Just a second, my lord. My lord, the state would refer this honorable court to the provisions of section 168. And
of CPA?
Of the Criminal Procedure Act, my lord. which provides for that a court before which criminal proceedings are pending may from time to time during the period of proceedings, if the court deems it necessary or expedient, adjourn such proceedings to any date on the terms to which the court may seem proper, which are not inconsistent with any provisions of this Act. So, my Lord, the state would say the court should exercise this jurisdiction, taking into account the provisions of Section 168 of the Criminal Procedure Act.
Okay. Anything else?
Nothing further, my Lord.
Or perhaps I should have called upon Mr. Esau, because I would want you to finish with his position. Mr. Esau, we wanted to advise the opposition here.
Thank you very much. In terms of my position with regard to the legal situation, I'm still finding myself in a limbo, in a situation of indifference when it comes to that, because I was successful with my Section 26 of POCA, the Prevention of Organized Crime Act, but I'm facing a situation whereby the state, or the Prosecutor General in fact, has launched an appeal against that judgment, and I want to avail to the court the notice of the Prosecutor General, against the judgment of the Jabber judge. I've tried by all means at least to address this issue of funding my legal representation. I've approached legal aid, and my application was unsuccessful. The reasons is highlighted there. I requested the Office of the Attorney General also for legal representation. It was unsuccessful. There is a copy of their response on my request. What I can state is that I am in a position to proceed with the pleading now onwards, because it's becoming now unfair for me to wait for such a long time, 5 years in prison, not even having the opportunity to plead. I've only pleaded on 3 or 2 of the indictments, and I want to continue with the pleading process. And I am now in the hands of the court. The court must decide that justice is done. Thank you very much.
If you were to, having listened to what the state has said and what I have discussed with the state, when do you think it is reasonable for us to resume in your situation? I mean, it's one thing to say, it's one thing to say now, let's carry on, and another thing to be reasonable about it and say the state has now said maybe 15 January, you see. What is your position?
Yeah, the state was saying that they are ready anytime to start, to continue with the pleading.
Yes, they said so until I asked them the question, what is your final position having regard to the position of others? And as you might have heard, they finally said they think the case must proceed from the 15th of January onwards. That's their final position. There's nothing wrong with you saying, as far as you are concerned, let's proceed now. It's your right, but I was simply inquiring in view of what the other side are saying and what you heard the other parties are going to say, which is in your memo. They don't want it until May 2025.
Yeah, my lord, I do take into account the positions of the other states and the other. And to be practical, maybe we should start as soon as possible. And the earliest date which was provided was January 15th.
Okay. So you would go along with that?
Yeah, as soon as possible. But I would like to start now.
Yes, I can appreciate that. I think you and I are in the same position. I would want to start now. All right. Okay. Mr. Engo.
It is indeed so that we have come up with a certain timetable as far as this matter is concerned, more particular address in the status report onwards, in paragraph 6 onwards.
Does my memory fail me, Mr. Engelbrecht? At one time you said to me, I'm available until Christmas.
You also, I'm going there, my lord. I'm going there.
Yes.
As far as the plea taking is concerned, me as well as my clients, more particular 7, 8, and 9, we are ready for the plea taking. There's no issues pertaining to that at any given time. I also hold instructions from accused 7, 8, and 9. If it so happens that I'm not available on a certain date, that they are willing to proceed with plea taking.
In other words, you are saying plea taking can proceed.
We can proceed. There's no quarrel or issues pertaining to that. Indeed. So the only issue basically was, as far as the date suggested by the state, 15 January, is it pertaining to plea taking or is it a continuation of the trial?
Well, what I must be, I don't know whether people lose peace somewhere. The first stage is to complete the plea taking, isn't it?
Indeed.
We have the other stage where people might want to explain their pleas, we get there. Then if we have finished plea taking, ordinarily we must proceed to deal with the case.
My lord, the reason why I raised that issue is that the court had pronounced itself, and where the court have said that the pleas must be taken, and after plea taken, the court will then basically give the parties time in order to get this house in order as far as the continuation of the trial is concerned.
No, that can still be the position, but all I'm simply saying, the natural progression of a matter, isn't it?
Indeed.
The pleas are completed, we get into the evidence, isn't it?
So, my lord, basically then my suggestions or my submissions before this honorable court still, that we are ready in order to entertain the plea taking, and then I would suggest that subsequent to that, then maybe perhaps then the parties must be called to a chambers meeting in order then for us to iron out the dates as far as the continuation of the trial is concerned. In the meantime, I've also received a request from the Registrar Office on which he requests us in order to make available our diaries. And indeed, they have asked that request is from dates commence on the 2nd of February until the 4th of April 2025.
Sorry, can you repeat that?
They have made requests for diaries to be submitted between period 2nd December 2024 up to the 4th of April 2025. That was a request. And indeed, I have submitted my diary to that effect. So my conclusion and my summary would be that we're ready as far as plea taking is concerned, and thereafter the parties been called in order for us to agree as far as the trial is concerned, the continuation thereof.
Yes, now,
As the court pleases.
you realize the position of the court has always been, let's proceed with plea taking. I think you would agree with me. We have heard Mr. Esau there saying, can we proceed with plea taking, although if other things come in between, he is quite prepared that it proceeds on the 15th. You have heard the state saying, well, as far as they are concerned, without taking into account the position of others, the matter must proceed any time. Now, I had indicated in the order, isn't it, that I would have wanted the plea taking to be completed before we break for the Christmas period. That would seem to be in order with you, isn't it?
Indeed. As the court pleases.
Yes. And you are also speaking for Mr. Siomunji, is it?
Indeed. As the court pleases. My Lord, my instructions from Mr. Sumunji as far as the plea taking is concerned, that he would not be available for the rest of the year because he have already other engagements. I don't know whether or not his clients are willing for the plea taken to stand alone. That I don't have. I don't have instructions as far as that is concerned.
The instructions you have
My instructions
are from Mr. Siomunji that the plea taking can proceed in his absence.
But he has informed me that he's not available for the rest of the year as far as plea taking is concerned. His presence, because he's already engaged in matters, and then his office would close down on the 17th of December. I have not engaged his clients to get instructions.
No. I'm still at Mr. Siomunji. Am I correct to understand that Mr. Siomunji's position with regards to plea taking is the same as yours?
No, I don't have such instructions.
What does he say about plea taking? When does you want it to be done? Are you going back to the
status report?
So he wants it 19 May.
That is not available. More particular in paragraph 4. He states his position that is not available, and then in paragraph 5 he indicates that it's only available since from the 19th of May 2025. That is the only thing that is indicated. As far as whether or not to proceed with plea taking, that I don't have any instructions, so I cannot commit myself on behalf of Mr. Simonji.
The rationale for your position is what?
As far as my position is clear on behalf of case 7, 8, and 9. We are at any given time this year, the plea taken can proceed.
Is informed by what?
I'm talking about 7, 8, and 9.
Yes.
That we are available. We are available. With or without me, my client is willing to proceed.
Yes. The with or without you, that's where my point is. The with or without you is informed by what?
Because I've already have matters engaged. As far as certain dates is concerned, I don't know whether or not on that specific date there would be a continuation. But I have liaised and informed my clients, and my instructions is quite clear, that they are willing for the matter to proceed this year as far as the plea taking is concerned.
Yes, okay. I don't like to leave things in abeyance or hanging in my mind. I would assume that if I directed that the plea taking must proceed, there may be times when you are not there.
Indeed.
And your clients would still be able to tender their pleas.
Indeed.
Am I wrong to understand that you've done your work very well and that your clients know the position, isn't it?
Indeed.
That is the question I would have asked Mr. Siyomunji as well, but unfortunately he is
I'm
not
in a
here.
position.
So the similarity with you and Mr. Siyomunji is where?
Then the issue was in paragraph 6. The issue whether or not I'm only available, let's say, from May 25 onwards as far as the continuation of the trial is concerned. But that position has changed in the meantime after the request, let's say, from the Office of the Registrar, and then I provide my diary. And what I would suggest, or what I would place before this honorable court, is that as far as the main trial is concerned, let me put it that way, after the plea taken in, I would be available from 17 February onwards.
Did Mr. Siyomunji tell you when he would be available?
No, I don't have such instructions.
So the main trial, you are available
From 17 February for that 2 weeks. I can make myself available.
and that would be continuous until we finish plea taking.
Indeed. Now, I use the word for the main trial. As far as plea taken is concerned,
No, sorry, I intended to ask about the main trial.
the main trial from 17 February onwards, for 2 weeks, because the parties have agreed during meetings that we will make ourselves available for at least 2 weeks per month.
Yep, if the parties can't agree which 2 weeks going into next year, maybe it will be my task to do so, isn't it?
Indeed.
All right.
As the court places.
So there is no similarity in position with regard to plea taking between you and Mr. Siyomunji's
Not at all.
clients?
Maybe perhaps I must address the issue.
So what did Mr. Siyomunji say you stand in for?
He basically asked me, Judge, I must just stand in for him as far as today's proceedings is concerned. No further instructions, no engagements, no dates have been agreed between me and Mr. Siyomunji.
Okay,
As the court places.
all right. Now we come to Mr. Shanghala. Are you speaking for others still?
Judge, I stand by what is contained in the status report.
Okay.
And
And that is for others as well.
that is correct.
And the others, does it include Mr. Gustavo?
My Lord, I stand by what has been submitted in the status report as well.
Is spoken to by Mr. Shanghala.
Correct.
So, just to, for clarity, Mr. Shanghala, you are willing that the plea taking proceeds, and as as we discussed with Mr. Engelbrecht, it also means after the plea taking, we proceed as necessary with everything else. 19 May, that's a date you would propose, isn't it?
No, I don't
Or
propose.
you have proposed
I haven't proposed the date, Judge.
for
That judge was.
plea taking.
Yes, I haven't proposed any date, Judge. That date, 19 May, was arrived at looking at Mr. Mbanga Siyomunji's diary when we met that day.
You have nothing to do with that.
No, I just, well, I typed up the joint status report. That's the extent to which I have anything to do with it. But the date is not of my making. I was.
No, we were looking, we are asking your debts. That was the whole idea for you to discuss and say, as far as we are concerned, we would only be ready to continue with the plea taking or even with the trial as from this date. So 19 May is not significant to you.
I probably wouldn't say that. What I wanted to say is that I was hoping to read your judgment, your last judgment, to understand the part, what you said explicitly about time to sort ourselves out. But then I also heard you say that the time has come, the trial must start. So I wasn't so sure. So I wanted to understand if there was time for me to be able to make the application, reviewing the decision of
so
the
shall I
Attorney
take
General,
it?
etc.
Shall I take it that what is contained in the status report is your position, as you said earlier?
Correct, Judge.
Yes. I think everyone is covered, isn't it? Is there anything you wish to?
Everyone's covered.
Yes, anything from the state in response or anything?
Nothing further, my lord.
Right. As I said earlier, I will have to give directions. I intend to do that by Friday. I hope too that as for Mr. Engelbrecht and those who gave your diaries, I hope the registrar's position with respect to your commitments is in sync with your position.
Indeed.
Okay. What I'm trying to avoid, where the registrar tells me that no, Mr. Because I expected, the reason why I said the report must be submitted through the registrar, isn't it? It was some expectation that she would comment on it, and I hope I won't have a situation where the registrar will tell me that, oh no, Mr. Engelbrecht is available these days, he's not anywhere. But if that is the position, I'm quite happy. So I intend to give my final directions by Friday, and I'm not sure whether it's necessary for parties to come or I just release my directions, indicating when. And as presently persuaded, I am inclined to direct that unless I reflect differently. Presently, I'm inclined to direct that the plea taking be completed before we break for Christmas. But I'm still reflecting on that. So I'm not sure that it will be necessary for the parties to meet on Friday. It will be enough just to, or my thinking is it will be enough just to give you my ruling on the way forward. Is there any problem with that?
As far as that ruling or reflection is concerned with it, and let's say by way of a letter or court order issued from the Office of the Registrar.
No, it will be a ruling. It will be a ruling on directions way forward, isn't it? Yes. So all I'm simply saying, in that one, then I will advise if for instance, I say plea taking begins on such a day, right? That will be it. All I'm saying, there's no need to keep calling you back Friday, come here for just that kind of ruling. It will be released.
That's the court places.
Yes.
Judge,
Yes.
may I, in the light of what you just said now, you said unless you are otherwise convinced, you may be of the mind that the plea taking can be completed before the break.
Yeah.
If I understood you correctly.
Yeah.
Perhaps three things just to assist in your thinking about that issue.
Reflection.
Yes, Judge. I only received your judgment moments before we began. Despite what the court had said, it was only available to me.
No, the court says, this court says so many things, like agree by Friday lunchtime, no one wants to do it. Release the judgment to the people, no one wants to do it. What do I do?
I think then the judge should make a ruling instructing the registrar's office to
What
ensure
about
that
you? When I said I want that report by Friday lunchtime, what ruling should I make?
I can prove to you, Judge.
No, I'm just not you personally. I'm saying to this, to the parties, what ruling should I make? Not to you personally.
Yes, the unrepresented accused had done their part well before lunch and sent it to all those other parties. Officers of the court, however, you have a special relationship with them. And just as you had asked that the judgment,
What special relationship do I have with them?
since they are your officers, you can.
They're
hold
not my
them
officers. They are prosecutor general. Those are lawyers.
They are officers of the court first.
Yeah, but
They are officers of the court.
I have no special relationship with them.
Whatever the relationship you define as a court vis-a-vis the officers of the
Yes.
court, you have the ability to hold them to account.
How would you suggest I hold them to account in this particular instance?
I would first request them to indicate why that was not done, when now you know that on our part, who are in prison, we had made it available to them. And then secondly, once you've considered their explanation, you are happy with it, you let them off. If you're not happy with them, you can caution them and warn them that if it happens again, you'll take further drastic measure. I would take that approach. What I wanted to address you, Judge, is on the issue that in the light of me receiving this, I may now want to study it. In fact, I want to study it and consider whether I may bring an appeal. Whether it is leave of appeal or appeal, I shall determine that, and I'm not seeking the court's advice on it.
You said you received the judgment today, is it?
Yes. And I'm hoping the 14 days are starting to run from today. As a reasonable court would consider, somebody who just received it. So that I think you would take into account. However, should the court not be convinced that it may want to exercise some patience in deference to my right to bring an appeal or leave to appeal, whatever the case is, then in that instance, I'm obliged to give notice in terms of section 106(1).
Now.
Excuse me?
You are giving notice now.
Well, I'm saying, we haven't arrived. It may very well be that the court will say, I agree with 19th May, and then it gives me. I'm just saying, because the court is still.
What I'm simply saying is, I would rather you do what you must do now. If there's nothing you can do now, you keep your arrows to yourself until you want to fire them when the time is right.
Yes.
There's no point telling me that maybe after Christmas I will do this, or after next week I will do this. You just do what you must do.
Yeah, so then when the moment arrives, I will be in a position to exercise my rights.
Yeah, you're right.
Judge, there's just one other thing that I wanted to request you to consider.
Yes.
I've seen this practice done in the Constitutional Court of South Africa. I've also seen it in the United States Supreme Court. I'm not aware that it is in Namibia, but I'm commending it to this court, particularly for my unrepresented condition. And it is this. An unrepresented applicant makes an application. Maybe you can allow 2, 3, 5, or even 10 minutes for that applicant to just advance their matter so that the train of thought is not disturbed. Why I say this is because when I reflect on what you said, well, towards the end of my presentation last, is that I can't just request to make other, I'd actually done a proper flow of my opinions and I couldn't get them across. Many of those things I couldn't get across. If you would allow that, that opportunity.
I can tell you my approach. When a matter is to be determined on the basis of affidavits filed, isn't it? And the written submissions, argument filed. I would have read through all those papers. I would normally just ask counsel or yourself to highlight a point or two, because I have all that you say. That's why lawyers say I stand by my heads. You have filed your heads, you stand by them, yes. In some situations, you don't even have to hear a party. If you say, I've written my heads, my argument is before you in written form, do you stand by those yes? Yes, I do. And that's the end of the story. If you want to highlight something, but we can't have a 15-page heads of argument, which he says, that's my argument before the court, then either you allow the person to read through all that, you are entirely entitled, you are very much entitled to highlight certain things. If it is on paper, you have placed your position on paper. If it is heads of argument, you have argued your case on paper. And I have read them. I would want to ask you questions. If I have any questions, if I don't have any questions, you stand by your heads and we decide the matter. I get your point. I'll try to give you some leeway.
2 minutes just for me to lay out.
Yeah, but in respect of applications, when you stand up to make an application, you must stand up and say to the court, I'm making this application. Even verbally, we can deal with them. But the applications should come in the form of, I would suggest I would do this. No. If you, a verbal application, sometimes it's acceptable, but you must rise and say, I make application for this.
No, that is clear. Lastly, on that issue, is just to say that there's an expression that is said that everything becomes a little different as soon as it is spoken out loud. So it may be written, but when it is verbalized, there is something that the human communicative modes, which is language, achieves better than.
Yeah, but the affidavits and the written submissions are made precisely to avoid a lot of oral submissions, because you will have thought through your case, you have made your submissions, you have made your argument. The court has to consider that. If you want to amend it, you amend. If you want to highlight a thing or two, that's it. But anyway, as I say, we will continue along these lines, helping you where we must help, and we carry on.
Lastly, Judge, if...
You can't have last and last and last.
Yeah,
yes.
I realized that I had, I wanted to say the last issue. Anyway, if there's anything in my papers, Judge, that you feel that you want to request me to clarify, I can clarify. But I find myself in a difficult position when the judge had opportunities to ask me, but doesn't ask me, and then makes conclusions about what is said.
No, if the judge is wrong in that regard, Mr. Shanghala, you deal with him. Deal with the judge if he's wrong in that approach. You appeal. They will tell you that the judge was correct or wrong. But anyway, the point of the matter, Mr. Shanghala, just to bring it to an end. The reason why you file affidavits are evidence. The reason why you file heads of argument, that's your argument to court. If you want to add, you can say to the court, I stand by my heads, but I want to make this additional point. We can't just have things written down and then we start all over again from page 1, reading through all that. Time is money.
I hope I haven't been of that dispensation.
No, you've been doing it perfectly so far. Right. So everything going well. I will hand down my directions by Friday. You don't have to be here. And then those directions will indicate whether we are starting in May or 15 January, or we are starting plea taking and completing it before the break. The court will adjourn.